Hi, welcome to Business Law TV. I'm your host, Anki Kwan. I'm a California lawyer, and in this episode, I wanted to talk about the differences between an S corporation and a C corporation and give you an example of an actual client that chose to be a C corporation, and we'll go through the reasons why she needed to create a C corporation instead of electing to be a S corporation. S corporations and C corporations are both corporations. That means that they're formed exactly the same way. The only difference between an S corporation and a C corporation is the way that you're electing to be taxed. If you want to be a S corporation, you have to meet certain criteria. You also have to tell the IRS that you'd like to be taxed as a S corporation. Taxation as a S corporation is the same as taxation as a partnership or a sole proprietorship. You aren't taxed on the corporate level, you're only taxed on the shareholder level. So you're only taxed on your income as a shareholder, you're not taxed on corporate income. Whereas in a C corporation, you're taxed on both the corporate level and on the shareholder level. That means that you're taxed both on the corporate income and on shareholder income, which is why they call that double taxation. You do have to meet certain criteria to be a S corporation. These criteria include your shareholders can be only limited to 100 shareholders. Your shareholders have to be individuals. You can't be a corporation, a LLC, a partnership, and most type of trusts. And finally, you can only have a single class of shares in a S corporation. You can't have more than one class of shares. A C corporation, on the other hand, can have an unlimited number of shareholders. You can be a corporation, an LLC, a partnership. You don't have to be an individual to invest in a C corporation, whereas you do have to be an individual to have any ownership interest in an S corporation. And finally, in a C corporation, you can have multiple classes of shares. Sometimes companies, when they're raising money, they want to create multiple classes of shares because they either want to give their shareholders preferences. For example, if they declare a dividend, they want to pay their preferred shareholders first. So they would create a different share class to provide these investors with preferred shares rather than common shares. Another reason is because the founder may want to retain voting rights in the company. So the founder would create a different class of non-voting shares to sell to investors. One of the clients that I worked with wanted to sell equity to investors as part of a crowdfunding offering. In a crowdfunding offering, you're raising small amounts of money from a large number of people. So in a regulation crowdfunding offering, it's very unlikely that you'll hit your target by only having 100 shareholders. Not only that, but this company wanted to purchase services from a corporation that agreed to provide services in exchange for equity in her company. Because corporations can only own shares in a C corporation, this company couldn't elect to become an S corporation. Otherwise, the company that they were seeking services from couldn't get any shares in their company, which is why this company decided that a C corporation was the best structure for them. Recently, this company bought back the shares from the company that gave them the services, and they also decided not to raise money using regulation crowdfunding. So this company can now elect to be a S corporation by filling out the appropriate forms with the IRS. I hope you found this video helpful. If you did, please share. I appreciate you tuning in, and I hope you have a fantastic day.